Hello and good evening. Welcome to Heritage University presents board training on rules. So welcome. My name is Melissa Rogers and I'm the Vice President of Business Development for Heritage Property Management. And I am so glad that you joined us tonight. We are in part 4 of a 7-part series. And tonight we're going to talk about the basics and the whys and the hows and the hopefully give you some really good reinforcement and encouragement about how to make effective rules for your community and how you can actually gain true enforcement and people to abate certain things within your association. So if this is your first time joining us, we'd like to let you know that while we are talking about community association specific information, we're going to be talking about things in a very general format, almost kind of like the impetus behind the reasons why you do your daily operations. So if you've got any questions from this evening, if you're a Heritage partner, certainly get with your community manager. And if you're not a Heritage partner, I certainly suggest that you get with your association's attorney should you have any questions specifically related to your documents and any of the information that we talk about this evening. If you are joining us and you are a repeat joiner, thank you so much for investing time into your association's success. We are going to answer questions throughout the process or throughout the evening, I should say. I'm going to answer the questions at the very end of the presentation, but you're more than welcome to go ahead and drop those questions in the chat box, which should be in the middle or the upper right-hand corner of your screen. I'm not sure if we're having technical difficulties or not, but if we are right now, you can at least see me. I apologize. And we are going to go ahead and get started in tonight's presentation. So go ahead. You are welcome to put questions in the Q&A box, and I will go ahead and take those at the end. There's a lot of content that we're going to get through this evening. So we're going to go ahead and get started here just in a moment. It looks like I've lost the screen, and I do apologize, Josh. I do not see the presentation coming up. Hello, everybody. Welcome to some technical difficulty that I'm experiencing at the moment. And I'm sure my team is working diligently behind the scenes to go ahead and get those taken care of. While we go ahead and get that hopefully adjusted, I'm going to go ahead and tell you just really quickly, as I indicated, we are in a 4-part series. So we've done 3 classes previous to this evening, and they are available on our YouTube channel in the event that you are not able to join us or sign up for those classes. We have discussed the basics of being a board member, the basics of what a community association is, the basics of what are governing documents and what comprise a community association. And then we also started talking about how to run effective board meetings, how to take the information of your association's actions and decisions and how you record those and make those available to your association. No, it is not up at the present. And then now tonight, we're going to talk about architectural control, so to speak, and the difference between the enforcement of the community-wide aesthetic or the initial use restrictions, and then the difference between, what creating or what regulatory authority you might have with your architectural control standards. So we are still at the moment attempting to get this operational for you. I thank you so much for your patience while we're getting this taken care of. Again, like I said, we are going to be talking about, I wonder, Josh, I'm going to go ahead and get started on the slides. Oh, yay, there it is. Thank you, friends. I was going to say, I was going to go ahead and just start talking until we got that taken care of, but it looks like it's up and running. So tonight, friends, what we're going to be learning about is the rules versus architectural guidelines. Okay. and how to establish very fair rules and guidelines, how to enforce those, and then really the best communication practices, which is communicate often. Okay, on the next slide, we're going to talk about now what's the difference between a rule and an architectural guideline. Okay, so a rule is a specific statement or a required behavior whose violation carries a penalty. Okay, penalties can be various, and an architectural guideline is a type of rule that applies to the appearance of an owner's lot, the exterior of their unit, or potentially in a condominium circumstance, the remodeling of a unit. Okay, next slide, please. So rules and guidelines really are comprised of three main things if you look at it this way. The first one is it definitely relates to the common property and individual units. So rules and guidelines in this area promote conformity and harmony. Number two, changes in architecture, the construction or the appearance of lots or units, rules and guidelines in this area establish and preserve harmonious design for the community and protect the property value. So one of the things that I didn't mention tonight, and I'm sure Kate has done a great job of dropping that in the chat, everybody that is joining us right now is going to go ahead and get a copy of the slides and the information. So if you are furiously taking notes, please do so, but I would love for you to pay attention and see the information because most everything that I'm going to be talking about is going to be located on the slide specifically. And then number three, the behavior of residents, guests, and other visitors, the possible impact on that person's behavior may have on another person necessitates these rules. So you're going to see common area property, changes in architecture, or the behavior that we're looking to change within an individual or those that live within the community. Next, please. So common areas of rulemaking. So as we talked about in previous classes, or if you're new to joining Heritage University, the declaration or the covenants, conditions and restrictions, if you might call them CC&Rs, you might call them covenants or just the declaration. The declaration is your operations manual as an association. So common areas where you might see rules are going to be further explaining pets, maybe children when it comes to your pools, parking, solicitation's a big one, maintenance of units, that's going to relate to townhome associations and condominiums, renting and leasing of units, which this is a super huge hot topic for a lot of associations right now, potentially use of common areas, facilities, and the ever ambiguous noise/nuisance. I should have put nuisance right there because I think everybody watching this might understand what I mean, and it's vague commonality, if you will. Next slide, please. Now we're going to see some common areas of architectural guidelines. So again, rulemaking is going to be done by the board of directors a lot of times, but sometimes that declaration definitely has an architectural standards or architectural controls section in there, chapter, if you will. And oftentimes, additional rules and regulations are adopted from those initial use restrictions or the architectural guidelines, and they're created. Some of these common topics are fencing. That's a big one. You know, a lot of declarations just say fencing is permitted. That is fantastic. That gives us absolutely no standard. Now, oftentimes that developer declarant might create that standard during that time period, and then the association can adopt a community-wide standard just by practice. By creating these guidelines is also super important. Decks and parking, very similar to the rules about parking policies previously seen on the last slide. Landscaping, doors, window treatments specifically where maybe you're an association where the curtains need to be white facing out, or the blinds need to be white facing out on all of the windows. Roof protrusions, Solar panels are huge right now, so that could be one thing that maybe your association is engaging the attorney to make sure that the declaration allows for a specific rule to be made, further outlining this condition for you. Outdoor equipment, exterior painting, and interior flooring if you're a condominium. Next, please. All right, so you might be asking yourself, okay, this is fine. Yes, I have seen these in my declaration, but really, where does this authority come from? And where do we get the empowerment from, as homeowners that are now volunteer board members, okay? First and foremost, state statutes. The state of Georgia definitely looks at court decisions as case law or, common case rulings, and a lot of our community association attorneys, whether you are currently represented by one right now for collections or maybe even general counsel, they keep you as board members educated by a lot of their service offerings related to education on court decisions and so forth. And then they also work with us and our managers to make sure that we're up to date with the most recent case studies and so forth that might have impact. Some of you might be hearing about the recent Senate bill that passed in Florida that requires some milestone inspection. So that's something that's sweeping the Florida market right now, for those of you that might know of it from the tragedy at Surfside. So again, these are, great ways that we can uniformly make positive changes to reinforce that harmonious environment and preserve your property values. And now number two, clearly the governing documents, as I've been referencing them. Governing documents, again, the declaration outlines the association and the owner responsibilities and or maintenance and rights. And then the bylaws often kind of give a little bit better outline for the board of directors' roles and responsibilities, maybe any committees, and how to run meetings of the association and to conduct its business. So definitely always have those and any amendments that you might have for your community. Go ahead, next, please. So make sure you always take a look at that. Get yourself familiarized with those governing documents. Okay, so we oftentimes as managers get asked a big question, which is the declaration is silent. So we're just going to go ahead and make a rule because we really need to create it, but we might not have the authority to do it. So as we learned in a previous class, rules and resolutions are truly only extensions of enforceability that's already allowed and offered to you through the governing documents, okay? Amending the governing documents or amendments might need to be the procedure that you must follow by creating new rules or behavior like we talked about in that first slide. So be very, very careful. So pay close attention to this slide here. A rule must not violate a fundamental constitutional right, okay? The rule must be consistent and applicable with federal, local, and state laws. The rule must be reasonably and relate to the operation and the purpose of the association. The rule must be reasonable in the sense that it cannot be overly sensitive or excessive, right? The rule must be fair and not create a separate class or group of individuals. And then the rule must be uniformly enforced. This is what we oftentimes hear about selective enforcement, or we've done some education in the past about making sure that you as a board of directors do not engage, or your architectural control committee does not engage in selective enforcement, because it can get the association into some hot water. So make sure that when you're taking a look at starting to create a rule, first take a look and ask yourself, okay, what do we want the purpose of this rule? And we're going to see this in a couple of additional slides moving forward. On the next slide, we're going to talk about in a little bit more detail what enforcing a rule is going to be like. Go ahead. All right, so steps in now developing. So we talked about how we gather the criteria, the thoughts that we percolate, and make sure that we understand that it has to be enforceable and it needs to be reasonable, right? Now we're going to talk about the steps for developing. Determine the need for it. So this breaks it down. Ask yourselves these questions. Why is it needed? Can it be perpetually enforced? Consider both the immediate and long-term implications. Is the rule going to be received well? Is it going to create future issues for future board members? Identify the sources of your community's authority. So make sure you check your governing documents, just as I talked about. Just because something you would like to add is not listed does not mean you can just adopt a rule. You might have to go through the amendment process outlined in your declaration. Define the scope of the rule. The who and the what, okay, needs to be covered in the rule. Apply an enforceability test and check it to be sure that it meets the what's when it's applied to a sample scenario. So maybe as a board, you can run through this as a sample scenario. Oftentimes during the debate or the deliberation process, when you're, reviewing and discussing certain motions that are made on the floor, this would be a great opportunity to test that before it is adopted and put into practice. You must, this box is a must, okay? You must give notice of any proposed rule that is going to affect the association. Okay, you have to, especially when it relates to whether or not fines or fees could be assessed as a result, whether it's an architectural rule or it's going to be a rule for enforcement. You still need to notice the entire association. So anytime you make a change, if you went from having the community-wide standard be 5-foot fencing, right? And now you're adopting that 6 feet is allowed, because your declaration only says that fences are allowed. You need to go ahead and notice the entire association that there's been a change, so people know that they can put that extra foot of fence in there. And this is actually a real example that I've had to manage through and communicate, and it's very important that be done. Act promptly on a proposed rule. So it is fantastic to sit and deliberate and to have good discussion, but once that rule is adopted, do not hurry up and wait. Meaning, all right, we're going to give everybody the benefit of the doubt and we're going to go ahead and give them a grace period. No, once it's published, you need to start the enforcement of it and then give notice of the adopted rule. This is necessary if people are voluntarily asked to obey it, right? Failure to provide notice of the rule creates plausible deniability for the member, and potentially, if it goes to court, you might, association, be responsible for the court costs, especially if they can prove that they weren't given, constructive notice of this. Next, please. So again, definitely take a look at what your governing documents notice policy is. You might have, if there's an infraction, they have 30 days to abate it. And then the second notice, and we're going to get into this here in just a moment, might have some intent to fine verbiage. It's very important that you take a look at what your declaration outlines as what that notice period looks like. And while making motions is a simpler process. Trust me when I tell you, we'd love for you to keep everything recorded in board meeting minutes. There are several benefits to enforcing a resolution, and a resolution is just taking, next slide, please. You're going to see what the contents of a resolution are as we come through this, but it provides a deliberate approach to making rules. A resolution is like a mission statement for a decision. Okay, think about it in that context. It provides consistency in the structure of the rule. So it takes the governing document legalese and it makes it digestible. I mean, it is the reference of the declaration, but it puts it in a format so that your owners and you yourselves as board members can understand it. And then it provides a formal record of the rule being made. So if you have joined us in any previous classes, I am a huge proponent, and Heritage is a huge proponent, that when you make resolutions, make sure not only your community manager or your management company, if you have one, has a copy of those resolutions. Make sure your association's attorney has a copy of those resolutions as well, because again, it's just further explaining what the operation is of a specific item, okay, or a behavior or a penalty, if you will. Okay, next, please. So here are the 4 things that must be listed in a resolution. I will also say, as a best business practice, we would really recommend that resolutions are run through an association's attorney, because again, it does have to have this very specific point, or these 4 specific points, which is authority. It needs to cite the board's authority to adopt this rule, the purpose. The resolution must state why, the scope and the intent. It needs to state who and what will happen, right? And what's the extent of which or that penalty. And then specifications. It needs to clearly and completely state what those what are bound by the rule and what people are expected or not expected to do. So authority, purpose, scope and intent, and then specifications. So a resolution format, I'm sure you can find one very, very easy. We don't like community managers to do those because, again, it does very specifically cite law. And so lawyers should be the best persons to be able to do that. Although we definitely understand that a lot of you are very financially conscious during this time period. And so maybe your attorney might have a draft sample for you and might give you that ability to do that on your own accord. So definitely get with your manager if you are looking to create any resolutions, and definitely make sure your association's attorney, if you have one, and you should, has the operations of your association. Next slide. Okay, so now we're going to talk about due process. I'm sure you might have talked or have heard, I should say, about due process and what that is. They're required to have due process. So this is a procedure, which is truly a formal procedure designed to protect the rights of all parties involved. Okay, enforcement is a difficult conversation. There are positives to it because its attempt is honest and pure and positive. Okay, but the reality of implementation is not as healthily received. And in fact, I was watching national news this morning about a woman who put a flagpole in front of her house, and the HOA has asked her to take it down. And I'm like, oh gosh, we don't need to be on national headline news, but sometimes that's just the way that it goes. And it's hopefully the next couple of slides will give you some really great encouragement about how this due process and how this enforceability and keeping consistency throughout your community can hopefully help you or alleviate some tension that you might be experiencing within your association. So there are several benefits of using due process, and we're going to talk about those on the next slide. All alleged violations are handled consistently, okay? So again, not only are we asking you not to go into rulemaking with selective enforcement, we also want you to be able to, with due process and a resolution, completely outline and create consistency that no matter what it is, you will have a hearing, not have a hearing, whatever that might look like. Use of due process procedure is recognized by the courts as an indication of legally valid rule enforcement, so that's another benefit. The majority of rule violations can be resolved via due process, meaning you can avoid going to the courts, hopefully, if you do allow for a hearing process, and we'll talk about that on the next couple of slides. The opportunity to be heard is non-threatening fact-finding forums often results in a person voluntarily obeying the rule. Listen, some of you might have a dispute resolution process outlined within your governing documents, and it might require arbitration. Arbitration is or the dispute resolution of due process allows for it to hopefully have conversation, then negotiation, and then hopefully some type of abatement with that, or at least some agreed upon settlement, so that either the fines and penalties are either waived before we have to endure, or the association we have to endure more money to go to court because we're not getting the answer that's necessary. Now, some do not, and the legal process is the way that you're supposed to go. So definitely take a look at your declaration. But due process, even if your declaration doesn't require a hearing, due process really should always be considered at the heart of listening to your homeowners. Okay, and it provides an opportunity to explore alternative means for resolution. Next slide, please. All right, so going into more detail, what is due process and how to address an alleged violation? Okay, so issue a cease and desist. It doesn't have to be as intense as you saying a cease and desist. Oftentimes your association gets, or your homeowners get, a courtesy notice. Oh, hey friend, I bet you didn't know. Our association does require that you have full mulch in your flowering bed. So we're going to go ahead and give you 30 days to get that. Just a gentle reminder. However, we certainly encourage that if that homeowner chops or is in the process of cutting down a tree in their front yard and they haven't gotten a modification process of approval, absolutely a cease and desist is what you need to do, because you need to stop that activity immediately. All right, so issue a cease and desist letter containing the notice of the alleged violation, action for required correction. I cannot tell you how many times that part is missing. I would love to tell you that everybody knows the responsibilities of lawn care, or that people know how to keep up or pressure wash, or how often you really need to clean the gutters, and they don't know. We assume, if we're in the know, that other people are. But oftentimes when we send courtesy notices or notice of an infraction, we forget to tell them, oh, hey friend, this is how you can correct that. Please pressure wash that. Or please paint or replace your gutter. If you didn't know, it's on the ground. Hey, maybe they didn't go on that side of their house and they didn't see that the gutter was down. Maybe they did, but I'm just saying, use that as an example, right? Okay. And the letter should also note the penalty to be imposed. So again, like I said, generally speaking, there's that courtesy notice or a first notice that just says, this is the declaration reference. This is the use restriction reference. Our regulation or the rule is you cannot have that portable basketball goal. It needs to be a permanent structure. Please remove it, bring it into the garage, and put in a submission for a permanent structure. That is a great way of, one, addressing the fact that you have a temporary basketball goal, and then you're telling the homeowner what it is that they need to do in order to become in compliance with the association standard or the rules. So now, if we're on the courtesy or the first notice, now we're going to the second notice. If the violation is not corrected within that timeline, oftentimes your governing documents might say 10 days, 15 days, 30 days, okay? They have a right to have that abatement period. I know some of you board members are already on that 11th day and you're like, second notice. I get it. I get it. Sometimes we really do need to curb behavior, and there's some better ways that we can do that while keeping maintained consistency on your notice periods. Okay. So now if it's not corrected in that timeline, we need to send them another notice, and we need to let them know that there could be fines or penalties. There might even be suspension of rights. We're going to see that on an upcoming slide. What internal resources we have to be able to help with enforcement. So think about it from that standpoint. You need to go ahead and give notice to your owners that, hey, they might lose access to driving their car into the community. They might have to walk. Just so you know, if we have to turn off amenity access because of a delinquent homeowner, understand that they have a right to get to their dwelling or to their home. That just might be a little bit more inconvenient for them to walk as opposed to drive. Okay, so just think about that from that perspective. I know sometimes that's a difficult one for board members to swallow, or sometimes homeowners feel that if we have to turn off their gate access, that we're restricting them from getting to their house, and that's not the case whatsoever. Okay, now in due process, it does allow for a hearing. Okay, and this is where you should let them know. And again, I'm a firm proponent of this. Even if your bylaws or your declaration does not require a hearing process, if your homeowner requests one, or really you should just adopt that in general, you should give that opportunity for them to be heard, because again, like I indicated, sometimes they're a first-time home buyer, or this might be their first time in the United States and they've never experienced a community association before, okay? And so a lot of you have the best intentions and want to do the right thing. And by allowing them this hearing process or the opportunity to maybe have a spirited debate, as long as we can debate and align at the end, right? Then we can go ahead and use that as a reasonable means of making progress. Okay, so hold the scheduled hearing if the violation is still not corrected by the time of that hearing. Next slide, please. So that's first, second, and third. The fourth, fifth, and sixth steps. So now that violation is still present. We told them that they could have a hearing. We've even given them a date. If the individual allegedly in violation does not appear for their scheduled hearing, you can either hold a default hearing, which is ridiculous in my opinion. If we're already at that stage and they chose to not show up, then we need to move forward with the next step. But, and again, I love that. The hearing panel's purpose is only to determine the facts. It's not to make a ruling. So that's a great point. When a homeowner requests or you offer a hearing for the homeowner to be heard, whether it is a denial of a modification request and they would like to have a hearing, or they chopped that tree down and now they got slapped with $1,000 fine and they're asking to have that fine waived and they just want to understand the conversation, you can start the meeting off by letting them know that this is just an opportunity for us to be on a fact-finding mission, for both of our conversations to be heard, and hopefully set a healthy boundary of expectations moving forward, okay? You are not going to have a decision directly made at that particular time. Oftentimes boards have to meet to go ahead and approve escalation of going to legal action, or there are different, based on your collection policy, different triggers might kick in. The third notice, if it's $500 or more, those types of things. So your communities are going to be a little bit individualized on this one, but then allow for an appeal, especially if this is a modification, a request to review the case for a higher authority, which is usually the board of directors. So generally speaking, most associations have that hearing panel is the Architectural Control Committee, okay, or the ARB, or the Modifications Committee, or the ACC, whatever your association's vernacular is for your architectural control. And then most of the governing documents have the authority of decision-making for architectural control resting with the board. So definitely check your declaration to see if it's the architectural control that makes decisions on modification requests or architectural requests, or if it's the board of directors. Next slide, please. And so I alluded to us talking about resources for enforcement. So what are some of the things that can kind of sting, or what are some of the penalties that you oftentimes see, or some actions that you as the association can do? First and foremost, suspension of the owner's voting rights. Okay. Number 2, suspension of the recreational facilities in the common areas, just like I talked about. Maybe you're letting them know they can't use the pool. Maybe you're letting them know they got to walk it home and find another place to park. Okay. Fines, depending on whether or not your declaration or any amendments thereof allow for fining. You should have a fining procedure and a fining policy in place. Notice that to the entire association so that they're aware of what could happen if they don't make or don't follow those particular rules, what the behavior is and can and cannot do. And then oftentimes, especially for associations who might not have any fining authority, and just FYI, friends, if you do not have any fining authority in your declaration, chances are definitely consult with an attorney. But if you don't have fining authority that in your declaration or your bylaws, that means you need to amend your declaration or bylaws, and you cannot just create the rule because you want to and you want to enforce. I totally understand where you're coming from and wanting to be able to do that. As amazing as governing documents and covenants are, again, they're intended to have really good purpose, but they're all not created equal. Some attorneys put different things in. Some of your governing documents right now are probably 60 years old. Some of them might only be 5 years old. So there's going to be some differences between how you're seeing, but most declarations are pretty vanilla. They're pretty bland, and there's a lot of subject to interpretation in certain parts. So this is where rules and guidelines are really, really going to be beneficial for you. And then obviously understand that self-help oftentimes is the board has the ability to enter upon with notice, enter upon an owner's unit for mowing their grass, and the landscaper that mows the grass charges $40 for that particular lawn. We need to bring it up to code because the grass is ridiculously high. And we go in and then we can specifically assess or charge back to that individual owner that $40 for that lawn mowing that we just did. Okay, that's what self-help is. Now, I see a lot of board members choose not to elect self-help because that can kind of get carried away, like, oh, what are the parameters for that? So I definitely understand apprehension, and this is a great conversation to have with your association's attorney. As managers, we're going to just be able to kind of tell you what we see and what our experiences have been. And I'm here to tell you that I've been to court and I've had to sit with an association who had the ability to evoke self-help within their governing documents. They did everything the right way. They sent the notices correctly. They did everything to the T, management company and the board, and the judge still awarded the homeowner because he cited, or the judge cited, that the board had the ability to just make the changes themselves and then put it on the owner's account and then go through the collection process. So definitely be careful, because judges are not as favorable when an owner has a high delinquency or a high outstanding balance that's related to fines. It's a different thing when it's related to assessments, but judges that, they kind of think it might be, as attorneys say, arbitrary and capricious if they see a lot of fines, but they're still up to date on their assessment. So go ahead. Now we're going to talk on the next slide about the external resources. Okay, so our declaration tells us in our documents that we might have some of that language on that last slide. Now, when we've exhausted that and we don't have self-help and we don't have finding authority, and you're like, oh my gosh, Melissa, We cannot do anything. People park on the street. It's driving us crazy. The grass is to the second floor window. What the heck can we do? I'm so glad that you asked. You may call the health department. You may call the zoning department, the police, the fire department, animal control, or an animal shelter. And those last two are real. Some associations, have pine trees or trees that are super close to their condominium, and they've got squirrels galore. And they have to budget in their annual budget for trapping and relocation. So that might have to be something. Manage an association. If you've got a lake or a retention pond, you're going to have geese. Wow, geese are really difficult to control from time to time. So some of these things, are legitimate, and you do have to have outside resources other than either a management company or the board of directors to be able to facilitate in this. So when it comes to the police and the health department, let's talk about that really quickly before we go on to the next slide. So the police are going to be, Heritage is a huge proponent of any association partnering with the community, local law enforcement provider. Generally, it might not have a designated for your police department, but oftentimes larger departments do have a community resource officer where one of their many job duties is to help community associations understand the regulations about parking and nuisance and noise disturbances and some other things when they don't own the roads or the streets. And partnering and getting the perspective from the local law enforcement can help you as an association. And just again, in that town hall meeting that you're having with the community, and they're like, what? We've had to change the bus schedule. People are parking all over the place. We can't get through. The mail's not being delivered. I mean, those are serious issues. So yes, there are some ways that you can, in addition to sending out notices or cease and desists to your homeowners, there are some external resources that we can do. The health department is a really tricky one. I've really only seen the health department get involved when you have a circumstance of a potential hoarder, or when, like a severely overgrown lot to the second floor, that creates rodents and some other, or it attracts potential local wildlife that shouldn't be there. And that's where the health department can sometimes, or code enforcement can come in and additionally help. If for one of those circumstances you do have a potential hoarding situation, you can also call the police and do a welfare check, and that can be done anonymously. And a lot of association homeowners do that from time to time when, they see that homeowner's newsletter is at the end of the driveway and you've been trying to reach them and you're just really not sure. They didn't tell you they were going on vacation. Go ahead and do a welfare check. Doesn't cost you anything. And again, the police is going to prioritize it based on the calls that are coming in, but it's a courteous way to be able to also check in and be able to have that additional help and resource. Next slide. I know I spent a lot of time with that, but we get a lot of questions related to external resources. So imagine a community association of perfection. Your residents live in harmony and peace, and everybody follows the rules. Guess what? Even in that la-la land, somebody's not going to like it. Okay, so always understand that when we're talking about that fair and balanced approach, you've got to look at every single side of a potential decision that you make. Okay, so even though most of your homeowners, and I mean like 95% of your homeowners are going to do the right thing, right? There are some people, man, I tell you, there's some people that just want to be the HOA's thorn in the side, or there are some people that feel that they should have something that is a restriction within the community. And again, your association might have some board of director discretion. You may have had a developer scenario where they allowed certain things that you no longer allow. And so those 5 homes have been grandfathered and they're past the statute of limitations. There are some times that we have to have this conversation, but understand we're trying to give you on the path of least resistance. It's an uncomfortable topic to have to enforce, just like collections is on a consistent basis. Nobody wants to have to file a judgment or put a lien on somebody's house, but understand that there is purpose and cause for the reason why these rules need to be enforced. Next slide, please. Residents must be reasonable. We've kind of recapped this a little bit. Rules must be reasonable in addressing the needs of residents, okay? They may address areas such as quiet hours, pets, common areas, hazards. We saw that on a previous slide. Developing rules requires not only careful and thoughtful planning, but also communication. Do you hear this word that keeps being repeated? Communication, communication, communication. I'll tell you, a lot of times when I talk to board members as they're considering new management or potentially adopting management for the first time, the biggest thing that I have is transparency and communication. We would love and do provide transparency, but board of directors, you've got to be the one to talk. Sometimes you have to lead the conversation, and oftentimes education, and we're going to see that here, is the best way to promote that harmonious, or at least, again, give that voice so that you understand and are empathetic to people's reasoning why they may not like something. But the board should definitely also make rules that do not ignore, discriminate, or favor any one group, which we talked about. That would be selective enforcement. And let me just tell you, your D&O coverage does not allow that. If rules are carefully drafted, the result should be a safe and harmonious living environment for all residents. It doesn't mean that 100% of everybody is happy. It says that you're doing your very best to preserve and protect and enhance the community value and the safety and the experience of the homeowners within the association. Okay, next slide. We want to make as many people happy as possible, but there are going to be those, unfortunately, that don't follow the rules. Okay, so while rules should mean that everything runs smoothly, like I'm talking about, here are a variety of reasons we often hear why people don't follow the rules. Some residents may not expect the rules to be enforced, like, oh, okay, wow, I didn't, I saw it, but I didn't really think that you guys were going to enforce that. Oh, okay, no problem, I'll get that fixed. Some residents may not feel that a rule is needed and may choose to ignore it. They might recognize that they can't have 4 dogs, but they choose to ignore it. Okay. Those who may not have been involved in the development or the decision-making process, that maybe didn't even read them at the time that they were adopted, right? They might be unaware that it actually happened. And so this is where utilizing, if you are a heritage partner, this is why we put your rules and regulations, your governing documents and so forth on Vanica, because we never want your homeowners to be able to say, oh my gosh, I didn't know that. You may not have known that. So, hey, no problem. Let me show you where this has been posted so that, and of course it's been, signed that it was approved. You've got meeting minutes to back it up. It's a resolution, so it's formalized. Life is good, right? Okay. Next slide, please. I'm sure you've heard possibly some more colorful reactions than what we're going to talk about right here. Wow, this transition is something fun. All right, reactions to violation letters. Once a violation letter hits an association, listen, there's kind of a joke, but not really. There's an inside joke for community managers. Never send violations on Friday. Never. Because the phone starts ringing and then you've got all weekend for homeowners. We obviously, sometimes that can't be avoided, but I can definitely tell you, if you, oh my gosh, this transition of the slide is so funny. If you are a board of directors that is self-governing your association, meaning you don't have a managing partner or a community manager, you probably get a lot of these, and you might even get homeowners that see you at the grocery store or out at a sporting event, and they're like, oh, hey, I see the Johnsons put in that fence. Are you sure that they're allowed to do that? Because, Joey down the street, his was denied by the modification committee. Well, hey, Billy Bob, you shouldn't even know that Joe's thing was denied. Okay, keep your privacy private. And as a board of directors, just because something may be grandfathered doesn't mean that you don't have the authority and the history backup as to why that was approved. And you do not have to share those private reasons with another property. Okay, so there is, some protection of people's ability to have some privacy. Next slide, please. It's better in print. Okay, friends, it is. All right, so we've kind of been talking about how to develop what the common, letter process might be, how to include due process as a great way to get perspective on a position that might be different from yours. And then when it comes to managing the community, if you've got questions or concerns about how they're going to respond, educate, communicate, and be consistent with both of those things. It's not enough to, hey, community, in 2023, we're going to update the design guidelines, and we're going to do this really big push, and we're going to send out the notification, and we're going to communicate with the community, and that's our objective for 2023. We nailed it. And then you don't talk about governance and enforcement again until 2029. Well, that really doesn't do a whole lot of consistency, because guess what? You're going to have homeowners that move in. And guess what? As a board member, hopefully, your job is to do such a great job in your position that you have other voices and other volunteers that want to come and serve when your time is up. So be consistent about the rules. Yes. Do you have discretion to make changes or to act specifically on one instance versus and it not be selective enforcement? Depending on the circumstance, definitely consult an attorney, but there might be that. But education, again, you guys are already 50%-ish, I'd say. You're already 50% there, because I'm going to count you plus for being consistent, because you're joining me for Heritage University. And that is a really huge step forward. Okay. Huge, huge, huge. We want you to be successful as a community, and we want you to be able to defend to the association or to explain to them it might not be savory. You might not like the decision. And I totally understand your perspective. Unfortunately, you bought a piece of property in this association. We're given the covenants. This is what you purchased into. How can we come to a healthy agreement? And if we can't, hey, friend, you do have a choice to move. Now, that should be the very last option, right? And some people, they want to just enjoy. This is the largest investment that they'll own, right? Or have in their life. So just this mentality of, okay, pick up and move to go someplace else. Not everybody has that capability to do that, but it is a choice. And there is that choice. So make sure that you communicate and that you explain the whys behind some decisions sometimes. That doesn't mean that your meeting minutes need to be a transcription. It just means that have some healthy backup, both to the association and for yourself as a board, so that your successors can also understand why you made the decisions that you did. Okay, next slide. All right, so we're going to talk a little bit more about those 3 points. Homeowners need to understand the rules, right? Starts when they purchase the community. Here, look at me talking about these things, right? A lot of associations have a welcome committee. That's a fantastic way to make sure that in addition to what they were offered at the closing table, that they are welcome to the association. Heritage offers a welcome letter. to our brand new homeowners because we want to be able to make sure that they know how they can get in touch with us and who manages their association and what the board of directors is doing for their community, right? And so again, if you're self-governed as an association, you might want to consider a welcome committee, or maybe you have that for your new homeowners, and that's always nice. Housewarming gift can be a high five or just a hello from a sidewalk. You know, sometimes just kindness is a good way to start, or a walk-in, a telephone. So beyond an early introduction of the rules, education also needs to be consistent and ongoing. So just like we're talking about communicate, make sure that you have a lot of communication, make sure that they have access to education. And again, you're already over 50% of the way because you've been coming to Heritage University and you know you've got great access to education. Next slide. Communication. Open communication between owners, board members, and any property manager is essential in resolving small problems, and definitely before they become big issues. Residents need to understand, it's kind of repetitive, but it's true. They need to understand what could potentially happen if they do or do not follow a particular rule. Communication oftentimes comes after a violation notice is sent. So sometimes people don't know on the front end, and then all of a sudden you get really good correspondence. As a board member, even if they cannot immediately abate the situation, if they are making contact with you, embrace that. You know, understand that that is their form of taking some initiative. Now, if they're asking for a hearing or something of that accord, work with them on that because they are engaging with you. It gets really difficult for association boards when the homeowner does not engage. They're silent. Those are the worst because we have absolutely no idea, right? And you know, maybe we have to go for a default judgment at that point, and maybe we don't get a response. Anyway, good open communication means clear dialogue, right? Just because something is released to the association doesn't always mean it's going to be savory, but hopefully when communicating it to the association, the whys, the hows, the whens, that will give them a better understanding. They'll feel included, even though they've elected you to make the business decisions on their behalf. When you give them the opportunity to feel included, it oftentimes takes away that, well, I didn't know, or the, well, are you sure about that? So communication is really effective in that way. Next slide, please. And then, of course, consistency. This is why we're talking about rules, regulations, and resolutions. These are within your control as a board of directors to be able to create and enforce, okay? Some of you might have to do an adoption or an amendment, okay, based on some of the information that we talked about tonight if you don't have fining, right? But be consistent and be able to defend your position if there is something that is not consistent, okay? You can't say that this person's basketball goal is allowed and that person's basketball goal is not allowed. You need to be able to defend why that is. And if it doesn't make sense, then you need to be able to have that discussion and you need to be consistent. Hey, as an association, you know that you don't allow basketball goals. Your declaration says it, but just about 25% of the association has it, and you're okay with that. Adopt a rule that says we recognize that this is what it is. This is the community-wide standard. And so definitely talk with your attorney to make sure that you can adopt that. You're not going to send violations to those that have basketball goals because you're uniformly not going to send it to anybody with a basketball goal. Okay, that was probably a poor example, but relative. Next slide, please. We're coming to the finish line. I know we've got about 2 minutes. In summary, if residents and owners know their voices are being heard, the reasoning behind the rules and why the rules are being enforced, and that they know that you're doing it consistently, you will find a drastic reduction in frustration, and you're going to be able to de-escalate a lot of fury. Next slide, please. I think we are at the finish line. Enforcement methodology. Okay, we've talked about this in a previous class. Some people have this school of thought that if it's not listed, then you can't do it, or if it's not listed, then you can do it. Just make sure that you take a reasonable approach when you're looking at enforcement. Next slide. I'm gonna kind of go through because we're hitting our time. Disputes. Okay, this oftentimes happens. Even in an ideal balance of those three items that we're talking about, disputes over rules will continue, and they will continue to challenge even the most educated board members. Don't be discouraged by this. It's simply a fact of community association living, and it's kind of like arguments. You learn a little bit after. You hope that you don't have to do that, but hopefully you are in good alignment. You allow for healthy conversation, and that's good communication. Okay, so with frequent opportunities for residents to learn about existing rules, hopefully you're continuing to educate them on community-wide standards. You can prevent disputes like this from happening, and hopefully preventing it from going to legal action. Next slide, please. Nobody wants to have to spend that money up front. All right, what are the rules for? I know this is like the last slide and the overarching question that every single one of your residents asks. The goal of rules in a community association is not to find a variety of ways to penalize residents. If you are putting fines on your budget, please don't advertise to your association that you are actively collecting penalties, and that that could come across as you're encouraging, or that you understand that you're just taking a position that, yeah, 30% of the owners aren't going to pay, they're not going to follow the rules, and we'll just collect fines from them. So just be careful on how that could look to your association. The goal for rules is to work towards creating a safe and harmonious community where quality of life is upheld by all residents, for all residents, and everyone is treated fairly and equally. Okay, that is truly the reason why there are rules. All right. Last slide is my contact information, and I am so grateful that you have joined us and that you've spent some time. Not only did you join us, you also stayed with us through some technical difficulties, so we sincerely appreciate that. And now I'm going to move to our questions to see if we've got anything queued up for conversation. It looks like we don't have any questions at this time. So we must have just done a fantastic job at answering all these questions, or I lost some of you during our technical difficulties. Not to worry, we did cover a lot of information, and I do hope that I answered any of the questions that you might have. Again, keeping in mind, this is all done in a general sense. If any of the conversation or the content that I heard today makes you question something, definitely get in touch with your community manager, get in touch with your association attorney, or if you'd like to, you can contact me directly, and I'd be more than happy to help get you some good attorney references or some really good management, just a thought. Again, as I talked about earlier, Heritage University is going to be doing 3 more classes throughout the rest of the year. I think our next one is about insurance and maintenance. It's going to be at the end of this month, and I'm going to be joined by our Director of Specialty Services, Danielle Williams, and she's going to talk to us about some insurance. And again, in this board basics class, we're breaking out chapters of the whys behind enforcing or operating a community association. So we're not going to be talking about why your insurance is incredibly high right now, but we are going to talk about when your declaration requires you to have insurance, you need to have it. And I know there's conversations out there about fidelity coverage and crime and cyber coverage and even your D&O policy. So stay tuned for that and mark your calendars. We have updated our YouTube page for those of you who have not had a chance to see any of our previously recorded classes. You are welcome to go to our website, heritageproperty.com, click on community-focused education, and you will be able to see our previously recorded or our upcoming calendar of events. So thank you again for joining us. Thank you to my amazing team behind the scenes who made tonight possible and allowed me to tiptoe through this really great class. I hope you have all gained some great content and some great information that will empower you to be a great ambassador for your association. So thank you for attending, and for those that are on replay, thank you for watching. I hope you all have a wonderful day, and I'll see you in the audience next time.